call the matter of Britton versus Hurst, case number 2021-5673 DC. All parties and attorneys could please state their name and appearance for the record, starting with the plaintiff, Dylan.
Your name, sir?
Yes.
Please place your name on the record.
My name is Dylan John Tyler Britton.
Okay, thank you, Mr. Britton. Are you representing yourself today?
Yes.
And counsel, if you'll put your name on the record.
Good afternoon, Your Honor. This is Attorney Allison Green-LaCour appearing on behalf of the defendant, Barbara Hurst, who's also appearing via Zoom.
Good afternoon, everyone. Today's date and time set for a hearing on two matters, a pro con and a motion to set aside the default. Take the motion to set aside first. Excuse me. This matter is being conducted by remote technology. Contents of this video may be the official record of a proceeding of the state of Michigan's 9th Judicial Circuit. Unauthorized duplication, distribution, or alteration of said content is strictly prohibited. In this matter, a summons and complaint was filed May 6, 2021. A default was entered June 15th, 2021. On July 14th, 2021, there was a motion to set aside default, and we'll start with that. If I grant it, we'll get the case up and running. If I deny it, we'll go forward with the pro con by Mr. Britton. Does that make sense, Mr. Britton?
Yes, sir.
Does that make sense, Ms. Green-LaCour?
Your Honor, just to note, these parties have not been married.
Did I say marriage? I'm sorry. I know it's a custody matter.
Yeah.
So
it's just it's a DC.
Why should I set aside the default?
Your Honor, my client was allegedly served by Mr. Britton's brother, who signed the affidavit of service. She does not have copies of it anymore. Additionally, today is allegedly his date to enter a default judgment. However, it does not appear this court has a default judgment. My client doesn't have a default judgment, and Mr. Britton has also not filed an AOP with the court to perfect his parentage at this point in time. So we don't know if he's actually the legal parent at this point in time. We don't have any default judgment to enter at this point. Also, the minor child is living with my client and has not seen the father, the alleged father at this point. At this point in time, we believe it's appropriate to set aside the default and allow these parties to move forward with the court process. We move forward to a pretrial, allow Mr. Britton time to provide an AOP to perfect his parentage, and to allow these parties time to seek to reach an amicable resolution.
Mr. Britton, any objection or any position on me setting aside the default?
I did give her proof of an AOP that I am on her birth certificate and everything. So
do you have that paperwork?
Yes, I do have that paperwork.
Okay, well, that'd be great. We can get that into the court, so that's a good start. She says it sounds like that she wasn't served by your brother. Do you know anything about that?
She was served by my brother, and she got the paperwork and everything, everything. She threw it back at him and closed the door after he served her. Okay. And then the next day she ran out, and I haven't seen her since.
And who is the minor child with the mom?
Yes, and I had her before she had her. I had her for from before the beginning of the year, January 11th. I had her, and she snatched her from my cousin. And ever since then, I had no contact with her at all. Like no communication, nothing. She would not answer my text. She would not answer anything since May 2nd.
Okay. Since May 2nd. Okay. All right. Anything else, Ms. Green-LaCour?
Your Honor, just to reiterate, if Mr. Britton does have a copy of the AOP, if we could give a timeline for him to provide that to the court and also to serve my office with a copy, that'd be appreciated.
Mr. Britton, can you get a copy mailed into the court?
I can bring it in tomorrow morning.
Okay.
I would deliver
staff
it.
will get a copy out to Ms. Green-LaCour rather than have it go in the mail. Well, that's the first step. Okay. Anything else by either party?
No, Your Honor, I just believe it's in the best interest of this minor child to set aside the default to allow both sides to plead this case and to have it move forward with the court track. And I don't think we can move forward today anyways, regardless, as there's no AOP on file or a proposed judgment.
Anything further, Mr. Britton?
The only thing I would want to have communication with my daughter. I want to be able to talk to my daughter, if that's okay.
How old's your daughter?
She's 5 years old.
Okay. Any problem with working something out, Ms. Greenlee-Core, between you and Mr. Britton and your client?
I'll be happy to speak with Mr. Britton. I don't know that my client will be amiable to having contact with the 5-year-old, as he hasn't had contact in quite some time, and that's not up for hearing today. You can certainly file a motion.
I'm going to set this in 2 weeks because I'm not going to play this game where we sit here for 60 days and someone doesn't see their child. So if I get an AOP, plan on parenting time starting. We're not going to play this game. I don't know what's going on between these two parties. I absolutely believe Mr. Britton that a brother served the papers and mom threw them away. That could be very plausible. I also believe mom, through her attorney, saying I didn't get the paperwork. That's very plausible too. Sounds like we need to babysit this case. So I don't want to wait 60, 90 days before this case runs through the system for a father to see his child. So we need to get to the bottom of this. I don't think I could put it in the hands of the parties. So I'll set this for 2 weeks. Sir, I want that AOP in the courthouse tomorrow. And then if the parties can't work out some sort of parenting time, then the court will have to do so. But I'm not going to let this linger. So I will grant the motion to set aside the default. Ms. Greenlee-Core, prepare that order. We'll see if we can get it in about 2 weeks. If the parties can't agree on some sort of parenting time, then the court will have to do so. It'll be with limited testimony, but I don't know what's going on with these cases, and I don't want to wait until it works its way through the system, and then a child's not seeing a parent for 60 or 90 days. So we'll get, if you could prepare that order, I'll see if my staff can get us in a couple weeks. If I don't have an AOP, then we're kind of dead on arrival, Mr. Britton. I need that AOP, okay?
All right, bring it tomorrow. Thank you, Judge.
Anything else, Ms. Greenlee-Core?
If we could just get the date on the record so I can make sure I'm available.
Yep. Let's see if we can get a date.
Can we do, or can you do August 9th at like 11:15?
I'm in front of you at 11.
Yeah, I'm trying to squeeze you in between an.
Oh, I've got an 11:30 in front of Judge Gorsalitz. I can do like before that or that afternoon.
Let me look.
I can do like 10:45 if you want me to jump in then.
Let me look at our 10:30. Yeah, that's fine. Let's do that. 10:45 on August 9th. Does that work for Mr. Britton?
Yes.
Okay.
Great.
It'll be by Zoom
What
again.
time is it again?
August 9th at 10:45 by Zoom.
All right, thank you.
And like I said, if the parties can work out some sort of parenting time for both parties to agree with, that's great. If not, we will be ready to go on August 9th to try to come up with some sort of plan with regards to this minor child. All right, we'll be adjourned. All prior orders remain in effect.
Thank you.